But Jagdeep Chhokar, can I come to you first and ask you what you make of the centre's defense that they have come out with this, actually not the defense, the centre's opposition to a lifetime ban on netas if they are convicted. They are saying 6 saal kafi hai. Zindagi bhar ke liye you don't need to ban netas. So what if they have been convicted?
The centre's response is not unexpected at all. This issue has been going on for 25 years, as far as I know, because I've been in this activity for 25 years. When the Supreme Court said that candidates contesting election should declare criminal cases pending against them, even then the Parliament had unanimously amended the Representation of People Act to prevent that from happening. And the Supreme Court then ruled that that amendment to the Representation of People Act was unconstitutional. Now, since then, there have been, at a very rough count, at least 10 petitions in the Supreme Court saying that people who have been convicted of serious crime should not be allowed to contest elections. And Supreme Court has repeatedly beseeched and exhorted the Parliament to make a law to this effect. And the Supreme Court has used very evocative terms that the nation awaits action by the Parliament, etc., etc. Nothing has happened. There is a well-established legal principle which is called filling in the gap in the legislation, which says that if there's a gap or a lacuna in any legislation, and the Parliament has not had the time or inclination to fill that gap, and the most important condition is the third one, public interest is suffering, then the judiciary has a right and a duty to fill that gap in legislation till the legislature does it. This principle was used by the Supreme Court in 2002 in our own case on disclosure of criminal antecedents. And this principle of filling in the gap in legislation has been used many times, and it is a well-established principle. Now, in this case also, what the Supreme Court is being requested to do is that since the Parliament has not felt it appropriate or it has not had the time or inclination to make such a law, the Supreme Court should fill this gap and correct this lacunae till the Parliament acts on it. So let the Supreme Court rule, and if the Parliament is not happy with it, let the Parliament undo it, and then we will see what happens.